Well, hello, my friends. I'm Nancy Cogar, your host, and this is Boomer Time. I'm so glad you're here. And if you're tuning in for the first time, welcome to our community. And if you're a regular, welcome back. This podcast is a safe, supportive space where I work to break down the complicated issues that we can all face as we age. Also, I try to share practical tools and resources to help you navigate those issues with more confidence. I've said it before, but every day there are more baby boomers hitting age 65 and beyond. And if you haven't started planning for your senior years, it's time. I know it can feel overwhelming, but remember this. I've heard it before. Failing to plan is planning to fail, right? So it's my hope that you'll avoid all that and Boomer Time will help. I also wanted you to avoid some of the biggest estate planning boo-boos, which come from taking those shortcuts that can backfire on you, your family, and your estate. I know that's absolutely not what you intend. And if you're an adult child of a boomer who stepped into that caregiving role, this space is also for you too. As an estate planning and elder law attorney, I see far too many families unprepared for the legal and financial twists that come with aging. Like I said, that's why I created this show. I want to give you a head start. I want to catch you up if you haven't started and give you a little peace of mind, maybe a lot of peace of mind. I hear that often. Well, today we're going to talk about some of the common shortcuts that people take. Maybe you've even thought about some of these when they think they're planning wisely, saving steps, time, and money. But I'm here to tell you in the long run, these shortcuts often backfire in big, painful, and expensive ways. I've seen it all the time, and I want you to avoid it. I also want you to avoid some of the biggest boo-boos that are absolutely not, I'm sure, what you intend by doing that. So stay with me, please, for the next 30 minutes, and I promise to leave you with some important takeaways. Maybe even a few aha moments, right, about choices you or a loved one may have already made and can fix. That would be great. And if you're new, why don't you reach out and say hello to me at nancycogar.com. I love hearing from you. Send me your questions. Maybe you've got something on your mind that you don't know the answer to. You might just inspire a future show. I'll be right back. Welcome back to Boomer Time. Today's focus, common shortcuts that backfire. You want to pay attention to this because I'm fairly confident that either you know someone who's done one of these or you've thought about it yourself, and you may not know the consequences even if you have done it. So this is an important lesson time. No judgment, just lessons that I want you to correct, okay? These are shortcuts that backfire. So let's dive in. I'm going to break these down into common mistakes based on common scenarios, okay, one by one. And at first glance, like I said, these may seem harmless, but I'm going to explain exactly why, even if it seems like a shortcut, they can cause so much trouble down the road. Sometimes when it's too late, you've passed away and then we realize the problem's there. So first of those is quitclaim deeds. Sometimes people call them quick claim deeds, but it's quitclaim deeds. This is a shortcut you would probably end up regretting most often and not even realizing what the problem was that you created. This is a big one. I see it happening all the time. All the time. I get asked about it all the time. All the time. Seems like a simple thing. Many people sign a quitclaim deed, which is just a deed that doesn't offer any kind of warranty, right? You're just transferring it down the line. So the quitclaim deed they sign is to transfer their house, convey their house, the family house maybe, to their kids, or maybe one kid, thinking, that'll save time, that'll save probate, avoid probate. It's the only asset I have. Let's get the house out of my name, If I end up in a nursing home, that's going to be terrible to have the house in my name. The state's going to take it away from me. I hear all that stuff all the time. And they want to protect it from TennCare or Medicaid recovery potentially. Those are all scenarios that I've heard over and over again. So, unfortunately, this simple quitclaim fix often does more harm than good. Did you hear that? Does more harm than good. Okay? Don't do it. Because here's why it's risky. First of all, from a tax standpoint, you're going to lose something called a step up in basis. I know your eyes glaze over sometimes when we're talking about taxes, but this is important, okay? Let's say you bought your house for $50,000 in 1950. I see that a lot, right? And now Chattanooga's booming. It's worth $500,000. Not unusual. So it's your intention for the kids to inherit it, right? And if they do inherit it, that's the key word, they will get it at whatever the value was when you died, date of death value. And that means significantly reduced or even no capital gains tax if they sell the house. So the problem is, okay, I want to go back to what happens if you quitclaim it. You will lose that step up, okay? So much for all that time you spent taking care of the house and holding on to it to try to increase the value. Please do not create an unwelcome surprise in a huge capital gains tax event for your family after you pass away. Nobody wants that, okay? Here's the other thing. Medicaid, TennCare here, can and sometimes will penalize you. You know about the 5-year look back. You know about how assets will count. And it makes sense if you've got money available to pay for your care. You should. And the government shouldn't be paying for it, right? I guess, Medicaid sees a quitclaim deed like a gift. You're giving it away. Or worse, a fraudulent transfer to an insider. That insider is your child, your family member, whoever you're conveying it over to. Okay? You're doing something that takes likely your biggest and most valuable asset. And by quitclaiming it, you're giving it away to that family member, that child, for nothing. This can lead to legal action to set aside the transfer altogether, even after you're dead. Pull it back into the court, sell the real estate, take it away from the kid. That could all happen. Okay? They can also make you ineligible for that assistance with nursing home coverage later, Houses are generally considered, your residence rather, exempted assets because the government doesn't want to make you homeless. So they don't count it against you on the front end. Problem is always the recovery, but there are things you can do as far as, estate planning, that you need to have somebody who knows, someone who deals with these highly complicated issues help you with those things. All right. Your house becomes vulnerable, also if your child goes through bankruptcy, right? It's their property now. Divorce, Could be part of a settlement. Say they get into a car accident and someone sues them. Lawsuit. Put a judgment on it. Maybe they owe back taxes. They don't pay the taxes on the property. All of that could get you in a big mess as far as your house is concerned. See it all the time. And, Chapter 7 trustees in bankruptcy have an obligation to liquidate what are called non-exempt assets, something that's not your house, value above any kind of homestead exemption you could take, because that's available to benefit your estate, pay your creditors, just like it might be available to pay for your care. This is almost certainly going to be one of those things that a bankruptcy trustee would eyeball. I would. So here's another thing you may not think about. Much more practical and simple, but same kind of scenario, okay? You quit claim your house away. It's not your house anymore, right? You lose control. You lose control over the asset. I know you're still going to live there. Your kid's going to let you live there. Maybe not. Okay. If it's their property, you could have one of those scenarios I just talked about. But, you can't borrow against it. So forget that reverse mortgage that you were going to think about. If you quit claim it, simply put, you just don't own it anymore. Your kids do, or whoever you quit claimed it to. So they could sell it. They theoretically could refuse for you to live there anymore. Could happen, You can't borrow against it, like I said. Bottom line, quitclaim deeds are a shortcut to trouble. Talk to an experienced attorney like me about better options to protect your home, your care, and your future. Here's another one. Adding your child to your bank account. I hear about this all the time. Sounds simple, right? I'm just going to put the one kid on the bank account, make him a co-owner, because he can write checks and he can access the account. Will work well. Now, here's the problem. Putting one child's name on your bank account just in case, right? Sounds convenient. Like I said, the child can pay bills, handle your money when you're sick. This is a big mistake. And I talk to my clients about this all the time. See, under Tennessee law, joint accounts, ones that are owned by more than one person, become the survivor's property when the other one dies. So what does that mean? It becomes the co-owner's property. So the child that you put on the account inherits the entire account, no matter what, your will says. As a matter of fact, your will won't apply because it's not your property to give away. Siblings can get left out. This can absolutely and does spark family feuds, sometimes even costly lawsuits. If your child's on the bank account, say they've got creditors, they can grab it too, even if they're not your creditors. Say your child has a debt, lawsuit. Your money, well, it's not your money, right, is fair game. I had a client, I've told this story before, but really appropriate here, who ignored my advice because I share this all the time. And he went ahead and added his caregiver to his bank account to pay his bills. Caregiver not related to him. So this is another degree of bad idea. So guess what? He died. He left $500,000 in his bank account. It became hers because she was the surviving joint owner. She legally owned the $500,000. That got the family's attention. I'm sure it would get your family's attention. So here's a safer option, okay? Use a power of attorney or set up a proper trust. We can do that as part of estate planning. It controls in a way that keeps the asset in your hands and avoids family conflict or that scenario later. Much better option. There are big problems oftentimes with beneficiaries, especially if you forget to have an alternate beneficiary. They call them contingent beneficiaries. Quite frankly, it's a small oversight, maybe not a small oversight, but it creates a big mess. And, it's easy to name a primary beneficiary on an account payable on death. You could put two, but don't stop there, okay? Always, always, always add a backup. Contingent beneficiary is what they're called. Why does that matter? Well, stick with me and I'll tell you in a minute. Hey there, we're talking beneficiaries. You know what? I tell all my clients that putting a beneficiary on an account, some accounts, is the best thing to do. And I'm going to talk about that in a minute. But, beneficiary designations are cheap, easy, and they work. That allows the asset to go directly to the beneficiary after they make a claim. Doesn't need court administration. I think they are absolutely appropriate. So sometimes they don't work on types of assets, but that's something you need to talk with me more about, okay? And that's one of the benefits of sitting down with me. So, uh, but we're talking primary beneficiary. Something happens to them, you don't have a contingent. Guess where the asset goes? Court goes into your estate. That's the default. So you may be creating more administration. But if you have an alternate, a contingent beneficiary on there, that prevents that from happening. Okay, you always got to have a backup, right? I think so. If you don't, it goes into your estate, you could be subjecting that asset, if it's something like a 401k or an IRA, to higher taxes or split in ways you never intended. Like I mentioned, retirement accounts, 401ks, IRAs, those type of things. They are the perfect asset for beneficiary designations and for contingent beneficiary designations. There are some new laws around that actually allow you to pass those to multiple people or even one child with a beneficiary designation that can allow it to not create a taxable event. And they can stretch the asset over time with IRAs. That makes sense, right? Life insurance annuities. Well, annuities are transfer on death brokerage account type things. You file a claim and it gets paid out with a date of death benefit. Or maybe it gets paid up over time. It depends on what the agreement says, right? But those can pass with beneficiary designations. So I think you need to have a backup. Here's a little pro tip for you too. There's a weird word I want you to remember. It's called persterpes. Persterpes. Looks like it should be per stripes. And maybe it's a typo. It's not a typo. It's persterpes. And that means that if the beneficiary that you've listed there dies, then their share would automatically pass on to their surviving lineal descendants. Okay, so that can help avoid gaps. Like, say you've got one son, you listed them as beneficiary, and you've got 3 grandkids. Something happens to him, then persterpes will allow that same amount to pass to his children, your grandchildren, in 1/3 shares. So it's helpful. It's another easy little thing that I would definitely recommend if that's your intent as far as the asset is concerned. Know this, though, stepchildren are not included in that per stirpes kind of designation. You need to list them specifically. They are not your natural heirs, right? So that's another important lesson when it comes to blended families. Blended families create all kinds of special challenges. And there's so many of them. I've got a blended family. You probably have a blended family. You probably know lots of people that have blended families. Maybe there's a second marriage. Maybe you blended assets. These are all things that you need to spend some real designated time with someone like me to talk through, because these can backfire on you big time in ways that I'm convinced you never intended. So blended families, you got two different families coming together, and that's modern families, right? You need modern plans, right? Today, very few families fit that old nuclear family mold. I don't see that very often. Maybe with some very older adults, but, down the line, the rest of the family has divorced, remarried, uh, married someone with children of their own. They've got stepchildren. Or, you know, I've got family members who technically are not related to me, but I absolutely consider them family. Maybe you've got that too. Here's why this is all tricky, okay? If you have a new spouse and you don't update your plans, your kids from your first marriage could get your new wife cut out of a disposition or vice versa. What? If you own a home, how's it going to pass when you're gone, right? If your spouse isn't on the deed or on your will, say you don't have a will, surviving members could take the house. The kids could take the house, and the new wife could have a child share of that. Goodbye to marital home, potentially. Stepchildren and step grandchildren have no legal automatic right to inherit from you unless you include them specifically. So the moral of that story is blended families require additional planning, special planning. Do not assume, and please plan ahead to protect everyone you love. I just think that makes sense, right? Why not take some effort to plan? Well, we've gone over a lot of different issues that I see come up. And like I said, these are all created by things that I think most people would consider good little shortcuts. What you don't know, you don't know. And like I always say, estate planning, aging, it is filled with minefields. You don't know until you know, and it may be too late at that point. So I want you to be more aware of these things. Here are some other pitfalls that I just wanted to touch on to avoid, because I see these all the time too. Say you've got a trust. Excellent choice. That may help you avoid probate, may make disposition of your assets seamless. It's private. It's less expensive on the long run. But what if you forget to put things in your trust? They call it funding your trust. A trust only works if you move assets into it. So don't leave it empty. I have people come in here all the time and they bring me a trust that they created previously. Doesn't have anything in it. The estate planner that they worked with didn't think it was his job to put the assets in it, just put an exhibit on the end of it and said, hey, don't forget to fund your trust, follow up. You need to be involved with the financial advisors. You need to make sure your clients understand, convey the real estate in there. Got real estate in another state? Convey it in there. This is the whole reason that you're creating the trust, right? You want to make administration simpler, easy, less expensive. You don't want to have multiple probates in multiple states if you've got property in different states. And that's exactly what would happen if you don't do something to address that. The other problem is don't leave the trust empty, like I said, because here's the problem. The trust isn't going to be gone just because it's empty. You're going to have to probate everything and then put it in the trust and then administer the trust. That's never any fun because it creates more time, energy, cost, etc. I know that's not what you intend. So simply put, don't forget to fund your trust. If you don't know what that means, find out. Call me. I can help you fund your trust. So don't hide your documents too well. What? I mean, let people know where your estate planning documents can be found, because if we can't find them, they don't do you any good. I'm referring to your will, your power of attorney, the other papers, where you've got those trusted people in place. If you need help, help them help you. Help them help you find those documents. Let us know where they can be found, because we are going to need those in order to take action on your behalf. If you don't find the will, there's a presumption in Tennessee here that you revoked it. And sometimes that means that it'll be administered as if you didn't have one. So don't do that. Here's a note on safe deposit boxes. Make sure someone has legal access, even if you die. So if you've got a safe deposit box and you're the only one on it, it's going to sound counter to what I said before, but make sure you have someone else on it, because the bank will freeze it when you die, and then you can't access it, or more likely, the people that you leave behind can't access it. And if you've got your will in there, they can't access it. So it's a problem. We sometimes see people having to create an estate as if there wasn't a will and have letters issued so that they can get to the safe deposit box to retrieve the will and then convert the probate to one following the will. Don't do that to your family. And, it's not like you're intentionally doing it. These are just things you wouldn't realize. So I hope this saves you some frustration, agony, cost, all those things. What about passwords? I can barely remember my password sometimes. Keep a list, keep it secure, but keep it accessible if somebody needs your password. Now, I'm not saying give your password to everybody. I'm just saying have it available, so if you forget or say something happens to you and somebody needs to access it, we can access it. Keep an inventory of your assets. So a lot of older people have bank accounts in multiple banks. Younger people don't seem to do that as much, but older people do. Sometimes they'll have accounts in multiple states. And it's okay as long as we know where they are. I'm telling you, lost accounts are a multi-billion-dollar problem. Lost accounts. Just look at the state's unclaimed fund site. You'll get a quick idea of what I mean. It's a big problem. Veterans out there, keep your DD 214 discharge papers handy. They are vital for benefits. I always ask for them, and I keep them in the file as a part of estate planning. You've got burial benefits. You've got benefits if you have to seek care. You worked hard for this. Make sure your family can prove that you're eligible. With that DD 214 is the way to do it. So just a few closing thoughts. Estate planning, long-term care planning obviously is full of hidden pitfalls. So it's my mission, Nancy Cogar with Boomer Time, to help you spot some of those ahead of time, sidestep them, and plan more confidently for these years ahead. So if this podcast helps you, please share it with a friend. Follow us on Spotify, we're on iHeartRadio, we're on YouTube, Facebook. Check us out and make sure to subscribe because that helps us grow the podcast. So it's worth it. So if you don't know how to do it, ask somebody how to do it and they can help you do it. It makes a difference for me and I appreciate it. Also, check out nancycogar.com. I've got lots of resources there and I want to get those into your hands too. So thank you for spending time with me on Boomer Time. I can't wait till the next time we talk. And in the meantime, take care of yourself, plan wisely, and be well. I'll see you next time.